Sir Bill, Ms Downs, Ms Wayte, welcome. I'm very pleased to have you with us. We've got quite a lot of things we want to ask you about. Two things I have to do more formally before the start of the meeting. The first is to say that after consultation with the Speaker, I have waived the sub judice rule, which enables us to discuss matters which are featured in some current litigation, but we will not be discussing cases as such, only some of the general issues which might touch on those cases. Because the delivery of a public service is involved, and I'm entitled to waive the rule in those circumstances. Secondly, we have to declare interests, some of which will lead to some members listening very carefully to what you say, but not asking you any questions at all. Interests?
Yes, I have practiced family and criminal law, both as a solicitor and barrister, and have received public funding, but I've never been involved in any tendering processes.
I wish to declare an interest as a solicitor and also the holder of a legal aid contract, so I won't be asking any questions today.
I've been practicing as a barrister. I've done family law, some immigration, quite a lot of crime. So I have received legal aid money in the past and may still receive some in the future. So I won't be asking any questions either.
Mr Buckland.
Thank you, Sharon. I declare an interest in that. I'm a practicing criminal legal aid barrister and still in receipt of fees as a result of work done prior to the election. It's been many years since I practiced in family legal aid, well over 10. That's my declaration.
And the rest of us don't have any relevant interests at all, other than our general non-prejudicial interest in the system working properly. And I'd like to welcome Mr Gummett, whose first meeting of the committee, to which he was appointed only late last night. And I would ask Mr Buckland to start.
Thank you, Sir Helen. The sub judice rule has been waived quite properly. I want to therefore dive straight into the High Court judicial review on the family legal aid contract. Why did the LSC think it was worth resisting the application by the Law Society?
Well, I think to start with, we would have preferred this matter to be settled by negotiation. That would have been our starting point.
And why wasn't it then?
On that point, we did enter into discussions with the Law Society, Resolution, the Legal Aid Practitioners Group and the ASA. That was probably at the beginning of August. And that those discussions and negotiations, many of which were without prejudice, were seeking to resolve issues through negotiation and through a review of the outcome of the family tender provisional awards. We agreed with all other representative groups other than the Law Society the terms of reference for such a review to be undertaken. But unfortunately the Law Society felt that they really did wish to proceed to judicial review proceedings rather than completing a review and a negotiated outcome where we possibly could.
Yeah, the LSC is not seeking to apply for permission to appeal the decision of the High Court. That's right, isn't it?
That's absolutely right.
So the decision is accepted. How much has all of this cost the LSC?
Well, we are still negotiating costs which have been submitted to us on behalf of the Law Society. Our own costs in relation to that, I think Ruth would know the exact figure. I think our costs for our QC were in the region of about 90.
Yes, it's a bit less than that.
Yeah.
We haven't actually had the final bill from the Law Society solicitors yet, but they've asked for an interim payment in the region of £200,000, which we've declined without some evidence of how that figure is amassed.
Are you able to tell us how much the whole tendering process that has now failed cost?
Well, it's not correct to say that the entire tender process failed, because in fact in 2010 the LSC tendered both criminal and civil contracts. Criminal contracts were let successfully. The civil contracts, we have let the non-family civil contracts, about 1,000 in all, and they started on the 15th of November.
All right, then the family element.
The family element, which obviously we need to have another go at, cost in the region of £1 million of project costs. That's over 3 years. As we develop the process and includes the tender itself. And in addition to that, we invested in some e-tendering software, which we'll have now and for the next 3 years, and that cost in the region of £600,000.
In accepting the decision of the High Court, would you accept their observations that the information made available to potential bidders was opaque and misleading?
I think our view was, with hindsight, that perhaps the information could have been clearer, as the judge said. I think, however, we would contend, and did contend in court, that our intentions were clear in the consultation documents, particularly as the consultation documents did say that it is our intention to include this criteria, or the qualification within the tender documents. So we felt that stating that that was our intention was clear enough. Clearly the judge didn't.
Yes, because it was the dual qualification on the Law Society's Children's Panel scheme and the Law Society Family Law Accreditation scheme that seemed to cause applicants quite a lot of problems.
The issue was whether they had sufficient time to be able to become a member of the panel.
Yeah.
Nobody was querying.
Not having realised that it was necessary for them to do so initially.
Yes, we would state that it was clear, and that's what we did put to court, that it was clear that our intention was to include that criteria. However, in doing that, the court ruled that people did not have enough time, once they realised that that was the case at the point of the publication of the tender documents.
8 weeks.
Yeah, that they wouldn't have had enough time to get that level of accreditation.
Can I add one point,
Yes.
Mr. Buckland?
Yes.
I think it's important to recognise the context, because the amount of work bid for by law firms was basically double the amount that was on offer. So it was inevitable that some people would be disappointed. So in other words, what happened, I think, was that the competitive criterion about panel membership, as it were, bit in certain areas more strongly than perhaps others would have expected. But I think the issue, and this is something we would certainly like to discuss with you, is that the sort of cake that the Law Society were looking for was rather larger than that which was available. And however way we were going to cut that, some people were going to be disappointed. And that is the fundamental issue which we are wrestling with.
Isn't that in the nature of a bidding process? That there were a number of practitioners will bid for more places they currently have, perhaps, hoping to enlarge their involvement. Others will do so thinking that they'll only get a proportion of what they ask for. So that's just bound to happen in a bidding process.
Indeed, but I think the Law Society were unhappy with the result that led to fewer firms being successful.
Well, hold on about fewer, from 2,400 down to 1,300.
Yes,
now, was that the aim of the LSCs? I don't think it was
No,
it?
it wasn't. In fact, I think it's really important to remember that of that large reduction in provider base, about 400 providers chose not to bid. So that...
Can you blame them?
Well, I don't think... Well, they chose not to bid, and therefore the reduction that came out of the bidding and the competition was significantly lower than the 1,000 that is oft quoted. So, no, we stated in our documents and in our impact assessments that we thought around 30% of the provider base would be reduced at the point of tender. If you take that 400 non-bidders out, that figure is not far off the level of reduction that we thought.
But it did lead, had it gone through, it would have led to advice deserts, would it not? There was clear evidence to suggest there were large parts of the country that would not have been provided with the services of a family legal aid lawyer. I
don't think that we would accept that point everywhere across the country. There are 134, 35 procurement areas across the country which largely map principal local authority boundaries. So those in all those areas, the work that we did showed that there were the procurement plan had not been delivered in just 2 areas. We ourselves, over and above the 2 areas where the number of providers we'd said were required for that procurement area were not forthcoming. That was Kensington and Chelsea, and the other one was Walsall, that's right. Now, that doesn't mean that we weren't concerned about coverage, in particularly some very rural parts of the country, Cornwall being one, actually interestingly East Lancashire being another part of the country where we had some concerns. And Northumberland, actually, we had some concerns, particularly around the area of Berwick. So we definitely did have concerns, but largely, in the overwhelming majority of the procurement areas, we felt that the procurement plans had been met, and there was sufficient provision. And I think it is really important that we remember that a reduction in the number of providers doesn't necessarily mean a reduction in service.
I don't follow. What do you mean by that?
That if you have sufficient providers in the procurement area to cover the work, that means that you do have fewer, larger providers, but access to justice is not being denied. There is all the work. There was no reductions at all in the budget or the level of work that was being offered in any of the procurement areas. So really it was, we felt that there were issues in some parts of the country. I don't think we'd necessarily use the term advised assets, but absolutely understand the point that you're making. Did accept that, really wanted to negotiate it, would have been prepared to say these areas we have not delivered to the procurement plans, we do not think there's an acceptable level of provision in these areas, and we would go out to retender in those specific areas.
Right.
Some areas actually ended up with more providers than had originally been the case, and many had a similar number, but there were some very clear areas where there were issues, and we would have liked to retender in those areas.
Would you accept that some of the nature of some of the more complex family law cases means that a large number of parties have to be represented in proceedings, which means you do need a large number of providers and separate firms? You'd agree with that?
We do, and the procurement plans covered that point.
Yes, each procurement plan required a minimum of 5 providers in any procurement area. That's based on the statistics that show the most common number of parties funded by legal aid in public law children cases is 3. So we felt that would have provided sufficient cover for conflict of interest cases.
You mentioned the Northumberland case, and I drew it to your attention, and I'm grateful for the action that's been taken to begin a new process. But it was a recognition that not just in relation to family law, but more widely, there were areas within areas, but of substantial geographical size, where the bidding process had, for various reasons, not delivered providers within reasonable access. Did you pick up the other cases just through your own systems identifying this, or were others like me banging on your door and saying this is not going to work?
No, we are carrying out a thorough outturn exercise, we're calling it, to look at the results per procurement area and per geographical area, because obviously, i.e. towns within a procurement area, just to check on access issues such as those you identified in Northumberland. We had already identified the difficulty, which, as you know, was due to one of the bids not being compliant with our rules. Because of an adverse peer review result, basically a finding of
a consortium
quality on a consortium partner. So what we've done, and this is what we've done previously as well as this time round, is put in place temporary arrangements which allow Berwick CAB in this case to deliver the service in conjunction with one of the winning solicitor providers elsewhere in the county who will be providing outreach services in Berwick to make sure that citizens don't have to travel too far. And then in the meantime, we'll retender, and that will enable the CAB or any other tenderers that are interested to apply.
Mr. Hood.
There is a feeling that perhaps you're not quite sensitive enough in terms of procuring proper coverage of all areas. You've said that you are concerned about coverage. Can I just put this to you?